Welcome to the Estate Blueprint, Planning Your Future with Tom Begley.
Welcome back to the Estate Blueprint, Planning Your Future with Tom Begley, where clarity meets compassion. Over the years, Tom has helped thousands of families avoid costly and sometimes heartbreaking legal missteps. I'm Sophia Morales, and today we're talking about some of the most common estate planning mistakes and how you can avoid them. This is Avoiding Common Estate Planning Mistakes. Welcome back, Tom. I'm happy to have you back with me.
Okay, good to see you again, Sophia.
So let's start with the basics. When I think about estate planning, and I know this was the case with my father, I think about, well, okay, that's all the stuff that happens when I keel over. But there's an incapacity aspect to it as well. So if I have a will, if I've drawn up a living will, and I have a power of attorney, am I covered if I become incapacitated?
I mean, you should be covered. So, most people, a lot of times they'll go to an attorney's office and they'll get a will and that's all they're going to get. And that, in my opinion, is malpractice because you could have the best will or best trust in the world drafted. But if someone faces substantial medical costs during the course of their lifetime or because of becoming frail and subject to predators, lose their money through an elder scam, then basically what they have could be diminished substantially. So really what they need to try to do is make sure that they have a good advance directive and a good general durable power of attorney in place. The advance directive allows somebody to make medical decisions, and not just end-of-life decisions, but day-to-day decisions, because we have a lot of people, such as individuals in nursing homes who, because of Alzheimer's or other forms of dementia, don't have the capacity to make routine decisions. And the power of attorney, if it's drafted properly, and do more than just what I call pay the bills. So as you mentioned, if you have a power of attorney, is that enough? Well, is it the right type of power of attorney? Every so often somebody gets, one or two page form, and actually in one or two states they actually will work, but in most states you need something a little bit more detailed just to do the basics. I have friends of mine in the financial services profession, and they tell me routinely that at least a third or sometimes half of the powers of attorney that get presented to them are kicked back for not being adequate. But also, with our elderly, a lot of times we're trying to save assets. And if somebody, for example, is facing long-term care costs, the typical power of attorney just allows somebody to pay the bills, and that's not good enough. So proper power of attorney allows somebody to, for example, set up a trust in order to transfer assets to expedite qualifications for long-term care benefits. And then, of course, to have the power to make gifts to go into those trusts, and not just for liquid assets, but real estate as well. So you have to have a really good set of comprehensive documents, the properly prepared ones.
Yeah, you mentioned a trust in there in the context of like the long-term care. Is that something that I can do even if I'm not sure I'm going to need it? Is there a drawback to taking that step?
Yes. A lot of times I get people come and they're very concerned about long-term care costs, as well as they should be. The average cost of the nursing homes in many states is anywhere from $12,000 to $15,000 per month, and that can wipe out your assets pretty quickly.
Yeah.
So a lot of times when people are getting, especially in their 70s, usually when they're in their 60s or below, they're not so much concerned about it. But especially when they start getting in their 70s, they're thinking, gee, I want to make sure that if something happens to me, that my family's not wiped out, because they remember that what happened with their mom or their dad or their in-laws or somebody that they knew closely, and how long-term care costs, dissipated everything they worked for during the course of their lifetime. So a lot of times people want to know, what can I do? And a lot of it's about timing. And I may have a different opinion than others. However, I sometimes tell people, be aware of the issue, but you don't need to have to immediately act. So the type of trust that you could set up for Medicaid planning or long-term care planning has a trade-off. On the one hand, if you transfer assets and you survive the 5-year look-back period for Medicaid eligibility, those assets will not have to be spent in order for someone to get eligible for Medicaid if they're otherwise meet the criteria, such as having less than $2,000 of accountable assets. On the other hand, the trade-off is, A, you lose complete control. You can't be the trustee of the trust. And the second is that you can't have any economic benefit. So you put your liquid assets in there, technically you're never supposed to get the income or the principal. So if mom and dad put too much money in there and they want to control their money, they're going to be out of luck. I've had cases where it's really important for people, especially as they age, to know that they're not losing their independence. And so the issue of losing control is a big one. A lot of times people can get over that, but when you're younger, you certainly, by younger I mean 70s, you don't want to have to be in a position, if you're relatively healthy, to have to turn to your kids and say, hey, can you spare mom or dad a dime? And
Yeah.
so there has to be a bit of a balance. So oftentimes when it's liquid assets, I won't recommend that people take that step immediately. The only exception that I will make, and once again typically try to tell people to wait until they're older, is with real estate. Because there's a trust you can establish. Some people call it a children's trust, others call it a residence trust. But it is one of the rare areas in the law where you can have your cake and eat it too.
Ah,
And what happens is it is irrevocable. But you can retain what's called a right to use and occupy, which is similar to a life estate. So basically, after the deed is signed by mom and dad transferring the house to the trust, and the trust has been established, yes, the trust is irrevocable, but because that right to use and occupy, first, nobody can come over on Thanksgiving and say, Mom, Dad, pack the bags, get out of the house.
yeah.
Second is because they retain that right to use and occupy, they're allowed in New Jersey to certainly keep their $250,000 exemption from capital gains if the property is sold during their lifetime, and the property gets a step up in basis when they pass away. So there's two things you can't do. There are two exceptions. One, you can't get a loan on the trust. Quite frankly, at that particular age, you really don't want anyone to do that. The only time I ever saw one person really want to do that was back when the market was really good some years back, and they wanted to borrow against the house so that they could actually take the loan and put it into the stock market. So we kind of discouraged them from that one. And then the second is, well, I mean, that's really the main one that we would
Yeah.
do, on that one.
Very good.
Oh, the second
So,
one is they can't sell the property. The second one, because
right.
you can, if you want to sell, your trustee needs to be the one that sells it for you. I don't think that's really a huge obstacle, because generally, if mom and dad are living in the house and it's time for them to leave, then the children are pretty amenable to helping them out.
Yeah, exactly. So back to the topic of a will. Will a will take care of handling all of my assets at the point that I keel over?
So, Sophia, that's the best question that anyone can ask about estate planning. For many, many years, a will pretty much covered everything that you had. But over the past 50, 60 years and change, many assets, and sometimes for folks, most assets will pass outside of the will. For married couples, many times you see that when one spouse dies, their will is completely unnecessary to use because everything was owned jointly with a right of survivorship, or the spouse was the designated beneficiary. Now, with a single person, there are three types of assets that pass outside of probate. The first is assets that pass with a right of survivorship, such as a joint bank account or a
Right.
deed where it's designated joint. So that's what we call passing by operation of law. So it doesn't matter what the will says. I could have a will that says that I'm going to leave my house to you, but if my house is owned with somebody else, that person's going to get the deed, and I will have made an empty gesture in my will for you. The other is contract assets, and that's the biggest one. And contract assets fall into four categories: IRAs, other forms of retirement plans, annuities, and life insurance. Those pass by beneficiary designation. So once again, it doesn't matter what you say inside the course of the will. If it's going to wind up passing through the beneficiary designation, that designation overrides the will. And the third, which we see from time to time, is paid on death or transfer on death accounts. For many, many years, people would have paid on death accounts, but those were typically what we used to call the Totten Trust. They were small accounts that grandma or grandpa would establish with a few $100s that, years from now, when their grandkids would grow up, they would get a little bit of a start in life. Transfer on death was evolved in many states where probate was very tough, like Florida, where people didn't want to get a living trust. I have a lot of reservations about those. I often call them the poor man's estate plan, because the value for assets can fluctuate over the course of time. And I've seen cases where somebody wanted to leave somebody X percent in the will, and they wanted to see somebody get Y percent as far as the non-probate assets in the because of the brokerage account, and then because of fluctuations, the percentages wind up getting skewed. So I usually don't recommend for that. But the important part is you have to know that this exists. And the reason you have to know it exists is because many people when they write their will, they're really putting down how they want to see all of their assets pass. And there are far too many occasions where somebody has these other types of assets and they don't realize that those beneficiary designations, if they're inconsistent with what your will says, can thwart the plan of your estate plans. And I've seen that happen a lot. One of the big mistakes I see is with retirement plans. We get families that think that they have 5 kids and they'll name one because they think that person's like the equivalent of the executor. However, if that person, tries to distribute the IRA among his or her siblings, then there's going to be huge income tax consequence.
Right.
But on top of that, that sibling may decide he's not going to cut his or her, brothers and sisters in on the IRA because legally it is his. And the other thing I see, which is somewhat doesn't make a lot of sense, is when you have people that have minor children, that they're 4, 5, 6 years old, and they're put down as the beneficiaries. So the nice thing you can do with these non-probate assets, however, is you can direct the beneficiary designation so that they would flow into your will or your living trust to make sure that your objectives are accomplished.
I like that. Well, and I know one of the sticking points when you're sitting down to create an estate plan is deciding who to appoint to act on your behalf. Who do you recommend that I appoint?
So actually, that's really another solid question. I guess we're on a roll today. And the reason why it's an important question is that back in 1990, when I got out of law school, the 2 big causes of action in the probate courts were will contests and contested guardianships. Outside of that, it was pretty vanilla. Probably in the last 30 years, the number one, if not the greatest growing cause of action has been fiduciary abuse or neglect. And what happens is, somebody's passed on or they're incapacitated and there's been, some mismanagement or actually fraud undertaken with their money. So the response, unfortunately, has been to go to court to try to stop that and try to get the money back. The problem is usually a person stealing money, it's because they don't have money and you have an uncollectible judgment.
Right.
What has been found out over the years is the reason people have these happen is they don't think about who should be the fiduciary. A lot of people, when they go to what I refer to as John Doe attorney at law, where they basically say, well, who do you want to have be your executor? And the name will be spouted off and the person will just fill in the blanks. But when you wind up going into depositions and discovery and you find out why a parent appointed a particular child to act as an agent under a power of attorney or an executor under a will, they usually make it for 4 reasons, none of which makes sense. The first is he's the oldest.
Right.
The second is they're a male versus a female. The interesting thing I used to see was more than anything was really old women would appoint men. And I had one case where this one lady had 3 brilliant daughters. I mean, all academically trained, and she wound up appointing her son-in-law, and he was nice, but as the old saying was kind of dumber than the box of rocks. And we actually had to go to court to get everything fixed. So, but basically he happened to be male. The third is they lived close by, and of course, my favorite one is I don't want to hurt their feelings, to which I've often told people, don't worry about that, you'll be dead. So, so the 2 reasons you need to, but it's interesting, probably at 25% of the time when people come into my office to set up their estate plan, I'll have sent them an intake form in advance. I mean, it's into that all the time. And they fill in their financial background, their personal background. And because I want them to have a good idea of who they want to appoint, I do have lines saying, who do you want to have be your executor? Who should be the backup? And I do that for all the documents on which you have an appointment. And probably 25% of the time when I tell mom and dad, these are the 4 things that you don't want, they'll stop me and say, oh, not her. She's awful with money. And they realize the person they put down was for those wrong reasons. So the 2 qualifications you have to have are pretty straightforward. One is impeccable integrity. I mean, you need to know that when your head hits the pillow at night, the person's going to do the right thing. And I'm not just talking about black and white honesty or dishonesty. One of the big things that I see all the time, and I told people I should start maybe charging for this quote, and that is that we have 7 deadly sins, but there's an 8th one that's called rationalization. And that's one where somebody's otherwise honest, otherwise good, but, they're a little bit of a bind one month, so they borrow a couple of dollars because they're going to pay it back next month. But the next month comes along and that doesn't happen.
Yeah.
So integrity is really, really important. And the second is common sense. You don't have to have an attorney or a financial advisor or an accountant be the agent, but you have to have somebody that has common sense, that they're going to pick up the telephone and call someone if they need help. And the best estates are ones where people know that they're going to call someone to make sure that their legal issues are answered correctly, that their financial issues are answered correctly, and so on. One of the things, for example, I saw that was unfortunate was years back where mom appointed her son over her two daughters for, of course, the wrong reason. And he was a nice enough guy, but rather than consult with the financial advisor, he decided to be what I refer to as one of the warriors of the internet. And looking at the internet, he had the cockamamie idea to say, oh, junk bonds. These sound like a good return on the investment. I found out about it because, mom was about ready to pass on within a couple of years. She had set up a trust. It had about $540,000. So if you divide that three ways, that's $180,000 each.
Oh.
I guess that was not going to be large enough of an inheritance for the son. So that's why he decided to throw the proverbial Hail Mary with the investments. Unfortunately, when mom died, the $540,000, rather than increasing in what was a growth market during that time, had plundered all the way down to $185,000. And
oh my goodness!
Because his sisters were suing him, and he didn't know if there was anything I could help him. I told him I was more than happy to offer my prayers on his behalf, but legally, I didn't think there was anything that anyone could do for him.
Yeah. Oh my goodness. So, talking about passing away and this sort of stuff, is there any special planning we need to do if we have, say, a second marriage or a blended family kind of situation?
Yes, and that's why, I tell people that as far as wills are concerned, one size does not fit all. Second marriages, for example, over the years, I can't tell you how many times I've seen the occasion where you have a husband and wife. They both have 3 children from a prior marriage. And because they love each other so much and they trust each other so much, what happens is they have reciprocal wills that say, when I die, I leave everything to you. And then actually, in the category of poor estate planning, not thinking it through, and that unfortunately means the attorney worse than the clients. He'll say, if my wife dies first, everything goes to my kids, and she says, if he dies first, everything goes to my children. So I call it death roulette. Whoever dies first, the first person's kids get stiffed. But the one you often see is they leave everything to each other, and then the 6 kids equally. But then mom dies and dad's suffering from occasional rationalization. I guess either he sees a girl that meets his fancy, or he basically hasn't heard from his stepdaughter in 3 weeks or whatever reason. And they come to the office and they're never saying that they want to stick it to their spouse's children. It's just, well, my wife's children, they're doing really, really well and they don't need the money. But my son, Johnny, he's really struggling, and I'm sure my wife would want this to happen that way. So now, in fairness, typically I found the risk of being a little politically incorrect. Women that have a second marriage, I think that for the most part that the maternal instinct dies about 3 years after the body. They're very pretty savvy. They'll make sure that if they love their husband, they'll take care of him. But they definitely want to make sure that when both of them are gone, that what she brought into marriage goes to her kids, and what he brought into marriage goes to his. I can't tell you how many times I've seen guys come in and they don't think about planning whatsoever. They have a great valuation for company. And if I could have the proverbial dollar for every time for the following phrase, I'd be a multimillionaire. And that is, she's a good woman. I'm sure she'll take care of my children. So.
And blood is thicker than water.
Maybe. Absolutely. Maybe. In this case, definitely is thicker than water. So, but that's one of the reasons that's the main reason. But as you also mentioned, there are other reasons. Sometimes you have a child who has disabilities. Mm-hmm. Sometimes you have a spouse that is going to go into a nursing home. Sometimes you have a non-citizen spouse. Sometimes you have issues regarding the inheritance tax. We don't have an estate tax in New Jersey anymore. And as you know, the federal estate tax only impacts individuals that have nearly $14 million or above. Yet we do have an inheritance tax in New Jersey, and there's some planning opportunities that you can take when you're leaving assets behind. And but you won't know how to do them if you just fill in the blanks.
All right, so it sounds like there are a lot of complicated variables that go into this. We're getting down to the end of our episode here. What would be your final words of wisdom to the listeners around thinking about the will and setting up powers of attorney?
At the risk of sounding self-serving, get proper advice. A lot of times people turn to internet programs and software because they want to make sure that they don't get gouged. And I get it, but I've referred to a lot of that stuff as an overcorrection. And basically, people don't want to get gouged by a, attorney. On the other hand, getting, junk to take care of your estate plan doesn't help you at all. But the one thing I found,
save money today and spend a bunch of money on the back end after you're killed over.
I told people once, a few times in seminars, they said what I thought about the electronic wills, and I said the internet wills. They said, well, they're great. Someone said, well, why? They're taking business away. They said, well, I don't think the guy's going to pay $2 for the internet was interested in my services to begin with. And secondly, I can't tell you how many times I've been able to go to court and make much more money correcting mistakes. Now, I'd rather not do that. One very, very important point, which I'll leave you with, when it is time to select an attorney, try to make sure you get someone that concentrates their practice in that. I found that years ago, by analogy, I had to get a hangnail taken out about 6 years ago. The podiatrist did it in a split second. It was wonderful. On the other hand, about 2 years ago, I had heart surgery. And as much as I liked the podiatrist, I was really glad that his face was not the one that I saw before the anesthesia kicked in. You would never think of doing that medically. And you shouldn't have to think about doing that with your estate plan. Make sure you have somebody that certainly treats you with reasonable prices and with compassion, but also knows what they're doing.
Those are some excellent words of wisdom. Thank you for sharing with us today.
Okay, it's good being here.
And thanks for listening to the Estate Blueprint. As Tom explained, estate planning isn't one size fits all, and small mistakes can have big consequences. With the right guidance, you can protect your assets, your loved ones, and your peace of mind. To learn more or schedule a consultation with Tom Begley, visit begley3law.com. And remember to like, subscribe, and share this episode with someone who's also thinking about their estate plan.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.